Hey, it's your old buddy Brian Parker bringing on the good stuff. Today we're going to do a first part of a two-part series. It's titled Settlement Tips in Response to Debt Collectors and Collection Law Firms. So you get a letter, you get some communication, possibly an email, maybe even a text, an initial letter from a debt collector, or these days from debt collector law firms. What do you do? Before I tell you what to do and how to do it, I want you to keep in mind a general rule in most states about settlement discussions. Meaning, the general, this is boring, but hang in there. The general public policy is that parties be free to discuss settling a debt or a lawsuit or something that's actively in controversy or in dispute, so that they don't fear those discussions coming into court to prove somebody is liable on something. So there is a rule, for example, in Michigan, it's in most states, it's 408. So in Michigan, it's Michigan Rules of Evidence 408. And that's the compromise and offers and negotiation rule, which says, I'll put it up there, Shazamsky. And essentially it's saying evidence of the following is not admissible to prove or disprove liability or for the validity amount of or of a disputed claim. So it's essentially a coverall so that you can freely discuss an ability or a way to settle a debt without having to fear those discussions are coming into court. There in Michigan, and this is a broad exception, not unique to Michigan, but one of the broadest I've seen in my review. The exceptions to that is if the evidence is otherwise discoverable, it need not be excluded merely because it's presented during compromise discussions. So let's keep that in mind. I've got this cool thing that I just invented and made me want to rush to the camera after writing for an hour or two. So this is my new invention, and before I give it to you to use and have fun with, or not use at all, it's up to you. I don't tell you how to love or to law, just do your thing in your state. So I call it my Consumer Mini-Miranda. So as you all know, as either debtors or subject to collection approaches or communications, or as a disciple of this channel, the Mini-Miranda goes like this. In fact, let's put it up there. Shazam. This is a communication from a debt collector. It's an attempt to collect a debt. Any information obtained will be used for that purpose. So that is a federally mandated requirement that finds itself in all collection communications. You've seen plenty of my videos about what happens when creditors use that. The creditors that are normally immune from the FDCPA, it makes them subject to the FDCPA. So as I was writing this, I was thinking, where are the protections for consumers? That is a consumer protection. They're getting told that a debt collector is pursuing them. However, I want something more, and hear me out here. I want to place on all communications. So if you call up, if you get a letter from a debt collector and you call up to negotiate before in your mind it's going to go to a lawsuit or it's going to get out of control, I want something that says, let's put it up, Shazam, this communication's from a consumer that disputes this debt and for settlement purposes only. There you go, you got the protection. Anything you say or provide as proof of ownership will be used for that purpose. Because the real bugaboo here of all my preachings and teachings is they are suing you without any proof of ownership. Even today, you remember my last video on securitization? There it is. Or my Wells Fargo video. The central theme of that is even creditors can't prove they own the debt when they sue and say they do, because it's all been securitized. So why can't you say the same thing? I want to get into settlement discussions with you, but anything you say will be used against you if it concerns ownership of the debt. Hear me out. the burden of proof on the plaintiff is to prove ownership of the debt. So they will not or cannot legally say, hey, that was during a settlement discussion. If you first given them that preamble or warning, your own Consumer Mini-Miranda warning, as the requirement of any lawsuit is to prove the burden of proof. Prove you own the debt and that Mr. Debtor owns it. That can't be excluded ever by a compromise rule. And again, even the Michigan rule says exceptions. If evidence is otherwise discoverable, it should not be, or let's put it this way, need not be excluded. So evidence of ownership of a debt can never be excluded. Why? Because you're entitled to see the defense against you, A, and they have to prove their burden of proof. So that's a cool thing I've come up with, thanks to writing for you and comments and questions. So I want you to remember these things, okay? Let's put this up. Shazam. Remember to use the 3 strikes rule. Remember that when you're settling debts. Remember you're being recorded. Maybe you're not. Assume you are. Remember that you must almost always repeat that the call or contact is made only for settlement discussions. Because on the other side of things, they'll use your desire to pay on this against you. It'll find its way in court, all right? And one approach they do this, even though the rule says that's verboten, is some cases say without controversy, there can be no compromise. Meaning, if you haven't been sued yet and you call up attempting to settle the debt on a letter, there's no controversy or case. So the compromise, your attempt to settle the debt, is not protected under the compromise rule. It's finite and it makes sense. But again, if there's no case filed, they will argue, well, he's not protected and he admitted he owes something because why would he pay on the debt? So be careful. Say, this is for settlement discussion only. I want to be covered by the litigation rules. And if you sense that they're going to still use it, get out of there. And remember that getting out of there approach. Remember, fear does not help. Stay in control with the below and above parameters I give you. That Consumer Mini-Miranda warning, while kind of cheeky, is a way for you to control them. Imagine, they are the person you deal with at a collection company. Their whole life of keeping their job is to make sure they give you the Mini-Miranda rule. They were sued for years for not using that Mini-Miranda rule. So that's embedded in debt collectors management. They tell their employees, make sure you use the Mini-Miranda. They use it even when they don't need to because they're fearful of losing their jobs or being sued. So give it right back to them. Give them the Mini-Miranda and start taking control. It'll drive them crazy because there's no rule that says we're not covered or we are. They are so scripted. The people Headset Harriet is so scripted, they can't come out of that box that is the script. You'll hear them say probably, wait a minute, let me go talk to my supervisor. That means on their computer, there isn't anything for them to deal with you taking control. So if that happens, that means you're doing good. Remember that information from you is not given in exchange for the collector to work on settlements. What do I mean by that? We call up the debt collector, we've got an inkling we're going to be sued, or you get this letter saying, give us the money. So you call up wanting to settle rather than have a lawsuit over your head or a debt over your head. They will start questioning you. Where do you live? How long have you lived there? Are you the only person living there? Are you married? There'll be all these personal questions where you will automatically answer because you want to get to the negotiation part. Don't do that. That search of theirs for information is not the admission price or the ticket to discuss negotiation. So cut them off. I'm here to settle this debt. You have my address. You have my name. You sent me a letter. Cut them off. And you must remember to use the 3-strike rule. You remain polite, forceful, in control, but not rude, and remember you're being taped, it may appear somewhere, and give them the 3 strikes rule, meaning make an attempt. If it fails and they won't work with you, later make another one, and then make a final one with your discussion. Look, it's the last time I'm going to do this. Very respectfully, I just want to discuss settlement for the purposes of settling this nuisance claim, whatever it is. So let's talk about what is your response to the response. What do I mean by that? It's crucial that when you receive one of these letters that you send a validation letter, a verification validation to collectors, to creditors. Use my new securitization letter. I don't know of a debt today, unless it's like a, there is one, credit union debts. They're pretty tight-knit. I haven't seen any evidence of them securitizing their debt. It's kind of a community thing. But generally, I'd say 99% of everything I see in my office has been securitized. Don't kid yourself. So I developed, here's my video on the securitization letter. I developed a way to seek securitization proof. At the very minimum, if they refuse to respond, that's evidence too. How come they're being so tight-lipped about something that my research clearly indicates that the debt has been securitized? So on my website will be all these letters, validation letters, MCM, UHG, MCM, UHG, PRA, LVNV funding, all these videos. Also, I'll have videos on how to send a validation letter, how to send a dispute letter, how to send these letters to specific companies. They're all up there. I'll also have on the website, the membership website at collectionstoppersolutions.com, follow-up letters. So attached to this video will be several letters for you to use and to cannibalize for your purposes and collector or creditor or debt buyer. You'll have the follow-up letters you need to send, because if they send you a BS response, have evidence that you sent a follow-up letter. Also, my new securitization letter, send it to Barclays, send it to JP Morgan, send it to Citibank. If the one hand doesn't know what they're doing, you've heard that before, so the debt collector may be pursuing you for JP Morgan, you send it to JP Morgan, they will respond, they won't go to the attorney at Podunk County, they'll just go, okay, check box, and it may contradict what they're telling you, because securitization is really part of a governmental watchdog, meaning everything they do, they have to supply to the SEC. Everything they do, and I read their financial manuals all day long, that say, hey shareholders, here's how we're making money. Securitization of credit cards is how they bring in income. They have to tell their shareholders. So this is all public knowledge, it's all government knowledge. So JP Morgan or Citibank may just, here you go, here's proof of securitization, without clearing it through the debt collector lawyer who's got 300 cases that day and doesn't really care. And that's a fact. When you send the validation letter, it is now, I'm going to use this word again, verboten to contact you ever again or your contract or your credit unless they have properly validated. When you get a BS response on the validation request, quickly follow up. Keep that immunity. What's the immunity? Under 1692GB, here, let's put it up, 1692GB, you're entitled to a cease and desist immunity. It says right there, you send this request for validation in writing, they must cease all collection attempts until they properly validate. The follow-up letter gets on the record that they didn't validate the debt properly. That's a paper trail for you where you didn't just say they didn't validate properly. Get it in writing. Courts respect things that are in writing because they take a picture of that moment. It's better, demonstrative evidence is better than you going, well, I think it was the 13th. You've got a letter and they signed for it because you sent it certified because you're Brian Parker's disciples. So here's what you must do if you are before. I'm going to just tell you this, all right? I preach, wait till you get sued. I do not recommend it. I do not advise it. But in 30 years, the amount that you save with a letter and dealing with Headset Harriet, who's on a script and cannot give you any more than she's allowed to, and she's scared to even go that far, is so low, the amount you're going to get discounted from her. Whereas if you get sued, now you're dealing with an attorney, and now there's time implications. They now have a bigger hill to climb of the burden of proof. They'll settle the debt for much less. That's my personal opinion. You go and do what you want to do. You're going to get much better savings if you're facing a lawsuit. Just keep your eye on the ball. Before you start any discussions with a debt collector or a debt collection attorney, I want you to say, communications from a consumer that disputes this debt and for settlement purposes only, anything you say or provide as proof of ownership will be used for that purpose. Why can't you have a Mini-Miranda rule? Anyway, this will drive them crazy, as I said. If you ever feel uncomfortable when you're having these settlement discussions, make sure you say, I am feeling uncomfortable because I'm talking with a debt collector. I do not want to give this information you keep asking for. Do you want to tell me now that you will not engage me in settlement discussions if I don't give you this reams of private information that you clearly already had? You sent me a letter. So here are quick, down and dirty things to remember in any discussions with a debt collector. Ready? There's going to be 10. Let's put them up one at a time. Number one, use your Mini-Miranda rule, meaning make sure they follow the rules, but you use your Mini-Miranda rule that I just invented. It can be yours if you want. Again, it will say, this communication from a consumer that disputes this debt and for settlement purposes only. Remember, we want to make this a settlement discussion so it doesn't find its way into a court proceeding showing you own the debt, because why else would you engage them? There's many reasons why you want to engage someone. It might not be because you owe the debt. It's a very good reason. You just want to get this. If you can get away from $100 when they say you owe $1,000, you're going to do that rather than employ an attorney. So there's many reasons you're protected. Get them to admit they received your validation letters. Number two, put that up. Number two, get them to admit they receive your validation letters. Once they do, and they're talking with you, you kind of have them. They shouldn't be talking with you without first validating. Even ask them, how come you haven't validated that and showed me ownership? If you call them, you're not going to sue them on that. But if they call you, say, hey, how come you haven't responded to my validation letter? If they admit to not having done that yet, or you can ask them, yeah, I just thought of something. As you're talking with them, ask them, okay, what's your address? Okay, what's your name? What's your last four? What's your employee number? Why can't you have that information? What's good for the goose is good for the gander. While I'm saying this tongue-in-cheek, control. If they have a right to ask you, you have a right to ask them. It may go south, but the 3 strikes rule. Be polite, be courteous, and ask 3 times for what you want. After the third time, look, I've really tried hard. I want to see what the basis of the lawsuit is. You're not helping me. This is all recorded, and it may bother the collector to have their manager hear this. In the old days, you would be dealing with the collector. The manager listens to all the conversations that are happening. I don't know if they still do that. The 3-strike rule is clear. You make 3 polite attempts to negotiate the settlement of the debt. Don't give a reason. It's nuisance value, but don't admit anything. Even though you have vast protections, it doesn't mean they're going to follow that, or at least try to squeeze it in. And once the bell is rung, is a great expression, the bell can't be unrung. So if they can get it in front of the court, and I see it all the time, then they will have, that bell can't be unrung, and the judge is already biased against you. Number 4, take polite control. Fear comes from lack of control. So using my techniques, especially that great Consumer Mini-Miranda rule, is you taking control from Headset Harriet. Always ask for a name and employee number, because you know you've heard this. You have a product that broke, and then you call up customer service, because previously you'd called up the warranty service, and they said you're completely covered, and then they didn't. So you call and complain, they go, well, who did you talk to? Like, you have to know all these things to have a warranty you already bought and signed. Have who you talk to and their employee number. They have names and the numbers. By the way, a lot of the names of collectors are fake, but at least have a date, a time, employee number. Make sure you state to them, today's date, I'm calling you, my name is Harriet Johnson. Take control. Give them reasons to fear you the same way that they're trying to get you to fear them. Take control. Remember that giving information, again, number 6, is not an admission price. You can give your name, maybe last 4. They already have your address. They wrote your letter. Now, can we please get to settlement discussion? Don't let them bully you, because they are trying to create a database towards suing you towards that judgment, and then enforcing the judgment, because now you told them, I work over here, I live over here, my wife does this, there's income. You're giving the ranch away. Don't. Settlement discussions can be used against either party, so that works both ways. However, again, that mini consumer rule, this communication, let's put it up again, Shazam, is from a consumer that disputes this debt and for settlement purposes only. Anything you say or provide as proof of ownership will be used for that purpose. You cannot abdicate or eliminate your rule that says the burden of proof rests upon the plaintiff. The plaintiff has to prove ownership. So that settlement discussion, you can ask for proof and that you will use it against them, where normally someone may say, hey, I told you that in settlement discussions. They cannot not have a burden of proof that shows ownership, so that rule can't knock out their requirement, their burden of proof. 8, keep politely asking for proof of their ownership and provide you with details. Never stop, because that's the genesis and basis of everything we do around here. So 9, limit the amount of time you're in discussions. You know, I give speeches on how to prepare people that are being deposed. One of the things I give them a short, concise way to answer any question. And number 1 reason why I do that, because the more time that a debtor or my client spends in front of a seasoned veteran litigator, she eventually is going to burn out and she's going to start giving away the ranch. So the less time you're on the phone, the more time you have to, the more easy it is to control the thing. But don't kid yourself. These guys do this for a living. You need to get out of there. So remember the 3 strikes rule. That's what that's there for. On the 3rd strike, politely exit. Number 10. I'm going to say this. You know the rules, what I'm about to tell you. Tape the discussion. If you're in a state that only requires one-party consent, and you're calling a state that only has one-party consent, you don't have to ask them for their consent to tape. They do it to you all day long. You might want to say, I'm going to tape you. Is that okay? That's on you. They generally will tell you they're taping you. So once, you may want to do this. When they admit they're taping you, say, okay, I'm going to be taping you then. See, you can't let them be over you and have control. And that's what it's about. Fear is at its heart, at its genesis, a lack of control. So these fun show notes that you're going to be able to read incorporate ability of you to take control. Even if you owe that debt, doesn't mean you owe it to this guy. They've got to prove it. They got a burden of proof. So don't go into this thing down here. You want to be coming out fighting, okay? You be on the offense, polite offense. So The ability to negotiate to avoid a lawsuit is always a good thing. We want to encourage that. But don't let your good faith be turned against you. And that's the purpose of these settlement tips I'm giving you today. So it all starts with your validation, creditor, and securitization letters. There's a ton on this video for you to pick and choose and cannibalize and use how you want to use it. Remember those great securitization letter. The toughest thing about securitization letters is saying securitization. Anyway, use the Consumer Mini-Miranda on them. It will mess them up and give you control. You may have someone go, there's no such thing. And you say, there is now. Are you telling me you are going to do something incorrect? Do you own the debt? Turn it right back on them. The 3 strikes rule, remember that, is a way to avoid mistakes on your part and also get out of that discussion as fast as possible. Again, we have lots of creditor validation, securitization letters, I said it right, attached. And I want to thank you again for watching. Oh, like, love, and subscribe. We're booming now. And I love doing these things. I love the comments. I'm starting to really dig this. I got to really force myself to do my work, which I love. So I'm working 12 hours a day and doing these videos, but it's a labor of love. And I love you. Thank you very much for subscribing. Good day.